I am a partner in the employment group in Los Angeles with Akin Gump, and my practice focuses on a wide range of employment matters with a focus on class and representative actions and other complex employment disputes. Before we get started, I just want to really thank the Southern California and San Francisco Bay chapters of the ACC for having us and allowing us to do this today. We really appreciate it. And with that, I'm going to turn it over to our other presenters to introduce themselves. And Nate, can you go ahead and introduce yourself?
Sure, thanks, Gary. Nathan Olson from Akin Gump's Washington, D.C. office. I've been practicing labor and employment law on the wrong coast for more than 20 years. And like Gary, focusing on a fairly wide range of complex labor and employment matters, but in particular, wage and hour discrimination and union type issues on a regular basis. And we'll be talking about a lot of those issues today.
Archie.
I am a partner in our public law and policy practice in Washington, D.C. I've been at Akin Gump for about 10 years, and prior to that, I worked for Speaker Pelosi as a senior advisor on council and helped navigate a pretty intense and broad range of issues through the legislative process. And now I advise corporate clients because of the leadership background. A lot of the things I work on are all over the map, but it's been a great platform because some of the biggest issues impacting the business community come across our desks at Akin Gump and our PLP section.
And I also want to thank Laura Vaughn, an associate in our Los Angeles office, who helped us put this together, as well as Lindsay Maxwell, business development manager here at Akin Gump. So with that, I'm going to let Archie kind of take it from here for a little bit and tell us and get us up to speed on the current political climate in Washington, D.C.
Okay, thanks, Gary. So as Gary mentioned, I'm going to start with a rundown on the current state of play, basically what's going on in Washington in a post-Trump world. Obviously, the election happened. It lingered a lot longer than some would have liked. But the end result after the Georgia runoff elections was unified Democratic control in Washington. So basically a Biden administration and a House and Senate that do have Democratic majorities, but they are very tight majorities. And so tight that we're roughly even when you look at the Senate, and Vice President Kamala Harris will provide a tie-breaking vote when necessary on various issues. So she is expecting to spend a fair amount of time in the Capitol, probably more than she expected because of this new reality in Washington. As we've kind of gone into January, it has been a rockier transition for a lot of different reasons that I won't go into because that could derail our conversation today. But I would say this, that because of that, there's a bit of a late start. All the trains are running behind. This certainly is a paradigm shift in Washington, because not only was the Trump administration unique in terms of its approach to issues, but also when you look at the players in Washington, now we do have a Democratic president. Speaker Pelosi is playing a different role, core and specific to the agenda, but in prior instances on a whole host of issues, she was very much driving the train with Senator Schumer, who also is playing a new role as a majority leader in a very tight margin. And we saw a lot of that this week as Senator Schumer tried to negotiate a leadership and power sharing agreement. And there was a lot of back and forth on a whole host of issues, but central to that discussion between Schumer and Minority Leader McConnell was whether they would get rid of the filibuster. I think they ended up, it was very much a testing of limits negotiation. And I think both walked away saying that they had won to some extent, in the sense that the filibuster isn't going anywhere immediately. But from that perspective, I think for most that were watching this closely, the sense was the filibuster is still in good shape from the perspective of it all depends on how the Republicans use their majority. If there is not dysfunction and there's not total gridlock, then things will move forward as the Senate has. And if there is, then you could see Democrats pushing back. And just to go back, I know the filibuster has gotten a lot of coverage, but I would say that the filibuster refers to the 60 votes in the Senate to get on to major pieces of legislation. And removing that and going to a majority piece would obviously give the Democrats more leverage. So I think right now we are in a very similar situation to past instances where the Senate has been this close. Now, as we kind of go to the trend lines and how that will impact the 2021 agenda, I'll go to kind of some of the underlying points that I think might be helpful to set the stage for our discussion today. One is it's COVID, COVID, COVID. All roads lead back to COVID in terms of the policy agenda. Now that said, that is not as narrow as one might think. The COVID pandemic, as we all know, has impacted the entire way we live our lives. So, but the Biden administration very much sees their success of their administration tied to managing the pandemic and rebuilding the economy. So as we go into this new paradigm in Washington, I think there are other long-standing trend lines that will impact the policy road, even when we're in a situation when the vaccines are readily available and when we have returned to work. And those, they're kind of two or three pieces I wanted to highlight. One is what the pandemic really highlighted for Democrats was a running trend line, but it just brought it home, was the economic disparity and the fact that, the whole dream of a middle class and the American dream was getting further and further outside of reach. So I think in the labor front, that will be an underlying theme, is the frontline workers who really put themselves on the line to make sure the rest of us could manage through this pandemic. And two, what are we doing for workers? There's also a political undertone in the sense that when you look at the Trump phenomena, yes, Biden very much won in a pretty significant way in terms of vote totals, but former President Trump did quite well as well. And so I think there's also a sense from the Biden team, okay, well, how do we address those issues and bring the country together? And part of that is this whole piece of how workers are treated, what kind of training they receive, what kind of wages they receive, what benefits they receive. So all of that will continue to have a long overhang as we move the agenda forward. So in terms of the pandemic legislation as we see it, one big piece that is a sharp departure from the Trump administration will be a robust federal approach, meaning rather than a patchwork of state laws, we're going to see more of an aggressive federal piece where Biden is really trying to use every agency, every tool at hand, and the president will continue to look for creative ways to get the job done. We saw that Biden released his stimulus package last week. And what I would characterize that as is an opening bid, basically a opening bid to begin negotiations. He very much wants to have a bipartisan approach and in hopes to work with the Senate to get that over the finish line. And so some of the labor pieces, associated pieces involved are obviously an extension of unemployment insurance, some measures of frontline worker protection, minimum wage increase, paid leave. There's also childcare money. So all of those pieces are just one part of the package. And what we've seen so far is that the road ahead is a bit murky. I mean, basically there are three options in terms of moving the ball forward in this package. One is that the president is successful in his bipartisan effort and he's able to pick off 10 Senate Republicans. That under that scenario, then we have a reset in Washington, and there's some confidence building on the path forward. The second piece is a Democratic only approach, meaning that the House and Senate would pursue a package under the reconciliation rules. The reconciliation rules are significant because they fast track legislation in the Senate, and they also allow a 50 vote piece versus the 60 votes. So a majority can get the ball over the finish line versus having to get the usual 60 votes in the Senate. This is not the first and ideal approach. I think Democrats would prefer to do a bipartisan negotiation, namely because reconciliation takes time. There are very specific rules associated with reconciliation. So the hope is that the bipartisan piece wins the day. And the third I would end with is a hybrid approach. Basically a hybrid approach where there's a smaller package on vaccines, maybe a UI extension on unemployment benefits, or maybe another round of stimulus checks, and then a longer term effort in the months ahead on another package. So as we look to overall to the Biden administration and this Democratic Congress, we're looking at in some ways a high water mark in terms of outside factors. The next stage is rebuilding the economy, and that's infrastructure, green jobs, healthcare, and that will also be extremely challenging, probably more challenging than even this package. So the Democrats basically have a few different tools, and I would say that we've already seen the first tool, executive orders, in a very, I would say, aggressive way, both in turning the page from the Trump administration policies, but also in terms of aggressively pursuing ways to stem the pandemic. We can also expect in the coming year to see a lot of congressional oversight. We'll see, we have both on the House and Senate, some very passionate voices on the Democratic side who will try to highlight issues on pandemic related issues and income inequality and racial inequities as well. And then third, regulatory action. I think we've already seen the Biden administration tee that up. So we expect that will be a strong platform for the Biden administration. And we saw that with President Obama, we saw that with President Trump, and I think we'll see more of that with President Biden. And last, I'll go to legislation. So I think to think of the upcoming year is probably two buckets. One is legislation, smaller, less high profile legislation, bipartisan, that moves through the committee process. And then the second piece would be some of these bigger high priority stakes are high. There are running deadlines. So for example, the next deadline on the COVID front is the middle of March, when unemployment benefits lapse. So from that perspective, we are going to see a very, I think there's going to be a lot more intensity in Washington, and there's going to be a lot of activity on the executive branch in terms of moving the ball forward, because the stakes are high on both sides. For Democrats, they need to be able to show not only that they can stem the pandemic, but they can rebuild the economy. And then for Republicans, they're negotiating and navigating a new world post-Trump. Then our last kind of piece that I would kind of focus on is that when you look at the administration, the number one indicator of how things will actually be implemented day to day is personnel. So on the personnel front, I will just start with, we see in terms of the Department of Labor, in terms of the appointment there, I'll turn it over to Nate, but I would just make one observation. When you look at labor issues going forward, the one piece that comes directly from the president is really bringing the country together to address some of the issues where many voters left the Democratic Party and they went to Trump because they felt like they had no hope. So I think what we see in some of these labor appointments is this return to a close alliance with the unions, outreach to those types of workers, and really trying to find policies that improve day-to-day lives. With that, Nate, I'll turn it over to you and to discuss some of the appointments and nominations a little bit further.
Thanks, Archie. And I think you're exactly right. Obviously, the key a lot of times in terms of what will happen at the regulatory level is who's put in that spot. And, kind of the initial indications are that this is not exactly kind of Obama administration 2.0, as Archie pointed out. Really, President Biden has been looking to try to bridge some of those gaps, bring union members back to the fold to the extent they've defected from the Democratic Party. And Marty Walsh's appointment as the Secretary of Labor, I think, is a sign of that. Marty Walsh is kind of ticks two boxes for the Biden administration. One is, he's a union guy from a union town, Boston. He was a mayor up there, and has a lot of credibility with that portion of the party, but also is not Tom Perez in the sense that he's been a mayor. He's had to kind of, work across the aisle at points. He's had to deal with a broader constituency than just his party. And so it's not quite the same in terms of how far he may go with things, I think the initial impressions are, than perhaps a Perez Department of Labor. Obviously, a lot of that depends on a lot of factors and things going forward. He could certainly come out of the box swinging and do a lot of things. And we'll talk about some of the initiatives he may pursue in some of the other areas of labor's portfolio. But certainly at this point, does seem to be a slightly different approach than taking the Obama administration. The other kind of, and I'll turn it back to Archie in just a second here, but you're seeing some of this too with even the appointments at some of the other agencies. So at the NLRB, the chair is going to be Lauren McFerrin, who's going to be held over. She's sitting there now. We're going to have to wait until summer until a kind of Democratic NLRB is fully installed and moves forward, and we have some of the terms expire. The most newsworthy personnel move in the early moments on the NLRB was the firing of the general counsel. That's unusual for an administration to come in and fire a general counsel. They typically do stay on for a short period after the transition. But the appointment, at least in the interim basis of Peter Orr from Chicago, again, there were far more, Chicago does have a reputation of being a pretty middle of the road, at least as far as the NLRB goes, middle of the road region. And so the kind of, I think the perception is that this is not not somebody who's going to come in and be extreme necessarily at the NLRB. Certainly will be aligned with the Obama or with the Biden administration's policies, but will do so in a way that I think is fairly straightforward. So turn it back to Archie real quick to talk about any other issues on the appointment fronts, but then also some of the initial executive orders coming out of the administration.
Thanks, Nate. I think there are just two observations I would kind of underscore. Is one, on the appointments piece, is that this very much is, as we've seen these executive orders, it's very much about turning the page. And I think on the Democratic side, there was a real sense that a lot of the agency work and charges really decayed during the last administration. So I think what we will see going forward is more increased intensity and energy to redirect all of that to address the challenge at hand. In terms of the executive orders, we saw basically two categories of executive orders last week. One was, again, turning the page from the Trump administration into this new Biden administration and reversing those policies that Democrats found egregious. And the second piece was also really indicating the laser focus on COVID and how the Biden team really, and the president, really views the pandemic, both from the stemming the pandemic, managing the pandemic, and then rebuilding the economy as front and center. And all of those have labor implications going forward.
And so that leads us to our first sort of substantive category here, which is wage and hour. And again, the issues in wage and hour kind of fall into two buckets. One is undoing the things that the Trump administration did, and the other is moving forward with some initiatives that have been on the Democratic wish list for a while. One of those is the minimum wage. And this is an area where there does seem to be some momentum legislatively to actually make a change to the minimum wage. And part of that is just a reflection of the change in the world, really since the Obama administration, through the Trump administration. Numerous states and localities have pushed the minimum wage up, in many cases to $15 and above. And that includes not just, deep blue states and deep blue cities, but also the state of Florida just had a referendum and passed a $15 minimum wage by a 60-40 margin. And so there does seem to be some kind of momentum behind the idea of moving the minimum wage up. It is part of the coronavirus relief package that Archie mentioned earlier. It's a straight $15 proposed minimum wage. I would be surprised if that goes through just kind of unscathed, but it's possible. The typical response from the Republican side is, first, if you're going to have that sort of increase, have it staged. But there's certainly, I think, still some resistance on the Republican side to going to $15 an hour. But I do think there is some bipartisan understanding that at some point there may be some adjustment to the minimum wage. The one kind of other issue to keep an eye out for here is not just the number that goes in, but whether Democrats are finally successful in getting some sort of automatic cost of living adjustment to the minimum wage or inflation adjustment. That's been a really big issue for them in years past. It's obviously never come to fruition, but there does seem to be some recognition that these issues sometimes, stick. And once the minimum wage tends to lag. And will there be some momentum for that this time? It's tough to say, but it's certainly something that Democrats would like to inject into the issue if they can. The other issues at the wage and hour side of things are really focused on issues like exempt classification. And right in that area, there's been talk about modifying the duties test. I think that's pretty unlikely, given kind of the longstanding interpretations that the DOL and the courts have given to those various duties requirements and the statutory exemptions there. But I do expect to be some potential movement around the salary threshold. And again, we're looking at two different factors here. One is the gross amount that's listed out. The Trump administration tried to kind of inoculate itself against a large increase during the Obama administration. They had pushed the salary threshold up to $47,000. The Trump administration rescinded that rule and then came back with a more modest increase up to $35,000, although that was still, more than $10,000 increase over what it had been. It's kind of an open question as to whether the Biden administration will go back and raise that salary level again. It's certainly part of the platform, but the Obama administration salary level was struck down by a federal court, had gone up to appeal to the Fifth Circuit. I think there's going to be some understanding that if they do raise that salary threshold again, it's going to face more litigation and whether they want to go down that path with other priorities they may have in the DOL space. The one thing I could see that maybe a little bit more likely is, again, talking about this cost of living adjustment or inflation adjustment to the salary level. That was part of the Obama administration rule that went through and then was overturned. But certainly you could see that coming back again. Same thought process from Democrats, that the salary levels get reset and they make sense on day one, and by year three they're not all that meaningful anymore. And so that is an area where we could see some rulemaking. It could be done through rulemaking in all likelihood, because the salary basis test is a creation, a rule creation. So that's where we may see some movement there. The other issues in the wage and hour docket the primary issues relate to joint employment and independent contractors. And this is another area where there's just kind of been this back and forth between administrations on these standards. And Gary's going to talk a little bit about the independent contractor standard in a minute, but the short history is the Obama administration put out administrative interpretations, not formal rules, but interpretative guidance saying that, kind of clarifying what the rules were for joint employment and independent contractor. And they really worked within the existing framework, took the factors that were kind of already in use by courts, and really just put a gloss or an emphasis on certain issues or certain factors. So in the Obama administration, this focus was put on, what's the kind of economic reality, economic dependence in the independent contractor context on the principal. And in the joint employer context, it's about, well, is there a right to control these folks, even if it's unexercised? That's the type of thing we'll emphasize there and kind of push the law in that direction where there may have been some dispute. In comes the Trump administration, pulls out the administrative interpretations, puts out its own regulations in 2020, kind of, again, reversing emphasis, still using a lot of the same factors, but talking about, well, it's about the actual control when you're talking about an independent contractor or a joint employer, not the exercised control, the actual control, not the kind of contractual rights they may have to control for those folks. And the independent contractor rule, again, coming back and emphasizing particular factors that on the employee side, they probably didn't prefer, emphasizing actual control and opportunity for profit or losses, kind of elevating those two up above the other factors. And Gary's going to kind of walk through those various tests right now. But I do expect to see some sort of activity here. The question will be, is it simply pulling back rules, which Biden has indicated he's willing to do? Is it going through the Congressional Review Act, at least on the independent contractor rule, and having Congress invalidate it, which has certain advantages to it, in that it makes it difficult to regulate or issue new rules on those issues going forward? Or is it some sort of legislation? And if you're going to get into some of these ABC tests that Gary's going to talk about, that's probably where they would need to go. So Gary, talk a little bit about these standards and where they're headed.
Right. Thanks, Nate. So just to kind of summarize what Nate was touching on here, on January 6th this year, the Department of Labor finalized a rule clarifying who qualifies as an independent contractor under the FLSA. And this didn't really implement a new test. It was still based on the economic reality test that courts have used, federal courts have used for years. But what it did is it really elevated a couple key factors, which is the degree of nature and degree of control over the work and the worker's opportunity for loss, profit or loss. And then some other factors that are still considered have been sort of de-elevated, kind of relegated to somewhat secondary factors: the amount of skill required, the degree of permanence of the working relationship, and whether the work is part of an integrated unit of production. And these changes overall were viewed as employer friendly and therefore has faced resistance from the left. However, this rule does not go into effect until March 8th, and likewise remains subject to the Congressional Review Act. One of the first things President Biden did was to put a halt on any pending regulations. So this rule has been will be essentially put on hold, and it's likely that Biden will seek to rescind the rule or may initiate new rulemaking. If the rule is rescinded, then the existing interpretations of the economic reality test will continue to apply, which again uses the same factors, but with somewhat different emphasis and in a manner that's viewed as more employee friendly and puts greater weight on some of the factors that employees might rely on in challenging their independent classification as an independent contractor. Now, one of the ambitions of the Biden administration is to implement something that's called the ABC test. Now, those of you in California are probably familiar with this. This is the test that is used under California's infamous AB5 law. And that's also a test that's used in some other states, notably Massachusetts and a few other states for certain purposes. But Biden has stated his intent to establish a federal standard modeled on California's ABC test for all labor, employment, and tax laws. This would represent a very major shift in the law in this area. So let me just walk through what the ABC test is for those of you that might not be familiar with it. The ABC test is called the ABC test because there are 3 parts. And for someone to be treated as an independent contractor, the hiring entity, meaning the alleged employer, needs to prove and satisfy all 3 of these elements. The first is that the A part is that the worker be free from the control and direction of the hiring entity, both under the contract and in the performance of the work, in fact. The B part is that the worker performs work that is outside the course of the hiring entity's business. And this is probably the factor that's viewed as the most challenging. The idea being that if the worker is performing work that is sort of part of the normal business of that company, then they arguably those workers are arguably automatically going to be employees. The C test is, the C factor rather, is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as that involved in the work performed. And I think this factor can prove challenging in many instances as well. So what you see here is that these are all factors that in one way or another were considered in the prior test in California, which we refer to as the Borello test, which was a court-driven test. But what it did is that was a multi-factor test. So similar to the economics reality test, the prior test in California was multi-factored, and courts could weigh those different factors in reaching a decision on whether an employee is, or a worker rather, is an employer or independent contractor. However, under the ABC test, all 3 of these factors must be met. If any one of these factors is failed, then that worker will be an employee. And that's one of the reasons why this test is considered so challenging for employers. Getting the ABC test through in legislation faces a lot of hurdles in Congress. Some developments in California where this test has been championed, I think, is dampening enthusiasm as well. First of all, although the AB5, the statute that adopts and codifies the ABC test, applies generally to all industry, there's many carve-outs, 60 or more, maybe more now with some new amendments that went into effect just this year, carve out certain industries and occupations. So what was designed to be a simple, easy to apply test now has become very complicated with all of these exceptions and exemptions. And I think some view that as sort of somewhat of a failure of the ABC test, that it needs all of these exemptions to sort of make it work. And then also in November, California voters passed a ballot initiative called Prop 22 that created a new category of worker for app-based transportation and delivery drivers, except, for example, Lyft and Uber drivers or delivery drivers for companies like DoorDash and Grubhub. Those workers are now by law deemed not, if they meet certain criteria, are deemed to be non-employees. And in return, they've gotten certain benefits such as minimum rates of pay and reimbursement, and some ability to obtain benefits, certain employee type benefits. And I think that has dampened some enthusiasm for the ABC test. Again, this was modeled largely on what happened in California and targeted not exclusively, but to a large extent towards the gig economy. So the fact that California voters have sort of rejected the ABC test with respect to the gig economy in large extent, I think has dampened some of the enthusiasm amongst the public, at least, for moving in this direction. And Archie, could you talk a little bit about sort of where you think this may be headed and whether this has any chance of getting through Congress, an ABC test like this?
Yeah, I think we have seen this in the past in the House, and I think it was an interesting dynamic because there was a fairly vigorous conversation within the Democratic caucus about how to proceed and whether this was too punitive. I think ultimately there were a small group of Democrats who voted against the effort, and I think what we will see in coming weeks is that there will be a very aggressive and passionate attempt by labor organizations to see the art of the possible here. But it certainly is a very steep climb, even in the House, let alone in the Senate. So I think as a standalone, in terms of being actually enacted into law, the chances are very slim at the end of the day.
Moving along, and just to finish up on independent contractors, regardless of which test does or does not ultimately get adopted, or whether there's changes in that test, employers should expect much more aggressive enforcement under the Biden administration in terms of trying to root out misclassification of workers. And one of the things that Biden has proposed is enacting legislation that would make worker misclassification itself a substantive violation of the law. So putting aside whether the misclassification results in things like minimum wage violations or overtime violations, he says he'll seek to make it, the misclassification itself, a violation of law. California actually has a similar provision in its labor code where a willful misclassification of independent contractors can result in penalties ranging anywhere from $5,000 to $25,000 per violation. I'm going to turn it over to Nate for a bit here to talk about President Biden's ambitions with respect to labor relations.
Thanks, Gary. And the first kind of step, kind of moving on from what you just talked about, independent contractors and joint employers, the Biden administration, as you said, this is going to be a theme across all platforms. They're going to want to make sure they're strengthening employee protections and making it easier for employees to be able to claim joint employment from multiple potential employers, but also claim employment status where they may not be. And in the labor context, that's going to mean taking on that old Browning-Ferris decision where trying to get back to that was issued during the Obama administration. The Obama NLRB had a much broader definition of employer than which traditionally the case, in particular because it flipped the switch from the actual control to potential control side of the switch. So that was pulled during the Trump administration. Biden has talked about trying to do that again through legislation and basically codifying that Browning-Ferris decision. Again, that's going to face an uphill battle in Congress, but there's some other levers he can pull on that as well. There are some breadcrumbs about what the Biden administration wants to do on labor relations. And again, this is one of the areas where there is a significant focus for the Biden administration. They want to try to deliver something for unions. They did not do a great job in the Obama administration of getting a lot of union favored legislation through. And so they see this as another attempt or another chance to help the unions out. And the PRO Act was passed in the last Congress. Some version of it will be passed again, in all likelihood, in the House in this Congress. It is a collection of fairly significant changes to union election procedures and other sorts of union issues. It tries to push through the ABC test or the Browning-Ferris test in terms of the way you classify joint employers and independent contractors. Again, it's the wish list of, there are no captive meetings for employers where they can go ahead and advocate against the union. There's provisions for first contracts so that if you go so far into negotiations and can't get to an agreement, we'll have an arbitrator impose it for you. It imposes a lot more significant penalties for people who are fired because of union activity or other prohibited acts under the NLRA, where there weren't that many significant penalties before. And it rolls that liability up to directors and officers. And those are a lot of red lines for Republicans. And so it's hard to see this going through, just because this is if on the labor and employment side, if there was one thing that Mitch McConnell could block, this would potentially be it. And the Democrats haven't really shown a willingness to break this into smaller pieces and see if they can't get them through. It'll be interesting to see if they do that, because they didn't do it the last time with the PRO Act. Will they try to break off some smaller pieces that it may be a little bit more palatable in this legislation and try to push it through as part of a broader package? Potentially, but there's just too many red lines, I think, in the PRO Act itself that probably make it, I won't say DOA, but very difficult to get through on Congress. The other kind of thing that's been on the wish list for a while for unions is the card check agreements and the Employee Free Choice Act. It's died several times. Again, I think it's the type of red line that's just it's going to unify Republicans, and absent some change in the procedures, is unlikely to be able to get through Congress. But there are some opportunities, I think, for a Biden NLRB to actually make some changes in the law. So one of them is trying to go back to that Browning-Ferris standard. Now we do have a joint employer rule from the NLRB, and so there'll be some difficulties about how they go about doing that. But there is an opportunity there to try to affect that independent contractor test once again. I think the problem you're seeing in both the DOL and the NLRB is that they have become so reactionary in that they are changing their standards every 4 to 8 years, depending on who's in office, is that at this point, some of these decisions are going to be very hard to uphold on appeal, just because there's going to be no deference to what the agency does, the NLRB does, because it's flip-flopped, 3 times in the last 12 years. And Browning-Ferris will be one of those. Specialty health, which was a decision of the NLRB that really gave the opportunity to organize micro units. Same thing, passed in the Obama NLRB, thrown out in the Trump NLRB, and likely, I think, to come back now. The question is can it hold up on appeal? And then the last one I would say is probably Purple Communications, which talked about the employee access to emails for organizing purposes. That's another target that will be gone after, I'm sure, by the Biden NLRB. But again, you're looking at Obama NLRB says it's something they can do. Trump NLRB says it's something they can't. And now we're back to something they can do. What standing will that have when you get to the inevitable court challenge on that? It's difficult to say. But that's the union side. Gary's going to talk a little bit now about EEO.
Great. So with respect to equal employment opportunity, the Biden administration has a couple key priorities. One is with respect to pay equity, and the other is with respect to LGBTQ rights. I'm going to talk about pay equity first. What we anticipate seeing here, or at least the efforts here, are going to be to try to narrow the employer's potential defenses to pay equity claims, and make it much harder for employers to argue that a pay disparity is a result of a factor other than sex. Another part of the agenda is to include, allow for expanded remedies such as compensatory and punitive damages, and also to institute a nationwide ban on requesting that applicants provide their salary history. And the idea there is that pay disparities get perpetuated from job to job when employers are basing an applicant, or to a large extent, basing an applicant's salary on what they were earning previously. There were efforts along these lines previously, but has not gotten very far and has not been taken up by the Senate. I would note that California and New York City already have salary history bans. So in those locations, employers cannot ask applicants about what their prior salaries were. So question becomes whether something similar could get implemented on a federal level. Employers should also anticipate that Biden will, or the Biden EEOC will reinstate pay data reporting requirements that had been implemented under the Obama administration, but then halted during the Trump administration. And this requires the reporting of fairly detailed information about demographics and pay ranges and pay amounts for those different demographics. And California, again, this is something else that something else where we see California sort of at the forefront. California just recently enacted a law that basically mirrors those reporting requirements, and that just went into effect this year. And probably in terms of timing, when a federal pay reporting requirement might go into effect is probably more late 2022 for reasons I'll get to in just a moment, having to do with the composition of the EEOC. Something else that we expect to see is Biden seeking to get enacted the Equality Act that would explicitly prohibit discrimination based on sexual orientation and gender identity under federal law. Now, this change may not have a great practical impact simply because in 2020, last year, the U.S. Supreme Court decided in Bostock versus Clayton County that Title VII does already prohibit discrimination based on sexual orientation and gender identity, even though it doesn't expressly state that. But there's also some other changes that could come with the Equality Act, such as requirements for diversity, actually certain reporting and disclosing requirements with respect to diversity of senior leadership and workforce, and also instances of engaging in the interactive process with employees. But as an indication of how great of a priority the Equality Act is for Biden, he stated that he intends to make it a top priority during his first 100 days. I'm not gonna spend much time on these other proposals, just in the interest of making sure we get through other things. But these are some other proposals that Biden has put out there having to do with pregnant workers, age discrimination, and harassment. With respect to enforcement in the EEOC, even though we have a Democrat president, the EEOC will still have a Republican majority until July 1st, 2022, when the prior chair, Janet Dillon's term expires. So we may not see major changes in policy initiatives until then, but we should anticipate an eventual shift to a more employee-friendly direction. But in general, employers should expect increased enforcement. Biden has proposed to double the funding for the EEOC. There's a likelihood of renewed emphasis on systematic discrimination and enforcement, and increased litigation in general against employers. Probably further attempts to push the boundaries of the law through law development and pushing novel theories of discrimination and harassment. And again, the priority focuses are going to be on pay equity, LGBTQ rights, and harassment more generally. Nate, can you talk briefly about paid leave issues?
Yeah, this is another issue that's been on the Democratic wish list for some time and is becoming much more normalized across a variety of jurisdictions in the U.S. And I think COVID has kind of brought this into a little bit sharper relief on the potential need for some sort of paid leave system in the U.S. So I think it will be a continued focus. It is, President Biden has already proposed extending the FFCRA COVID-related leave program and actually expanding it, moving it beyond just employers that have 500 or fewer employees. They would continue to get the tax benefit, but everybody over 500 would have to provide some level of COVID leave too. That's something that may just not arrive in time to have too much of an impact, even if it does pass. But I do think it's somewhat of a stepping stone to to a broader discussion about paid leave. And again, I think that's something that they'll try to push through Congress at some point. And I'll turn to Archie in just a second to give her get her thoughts on where that sits in the kind of constellation of priorities that may get pushed through. But the other thing to remember here on paid leave, and we haven't called out the federal contractors yet, but you will be the guinea pigs. And you can basically expect everything that came out in the Obama administration as to federal contractors union neutrality, which is a problematic issue because of free speech and some other issues, and was struck down. But executive orders on discrimination, on equal pay, on paid leave, having some requirement that federal contractors have paid leave. I would expect those sorts of actions to come back and potentially be expanded even. But in terms of a legislative solution, I think my personal view is that minimum wage is one that has the best chance of going through a minimum wage increase. But Archie, I know that this has been on the legislative agenda before. What are your thoughts on something like this getting through?
So starting with minimum wage, I think that the challenge with minimum wage will be that I think you're absolutely right in the sense that it's coming at some point. The question is when. And I think because we are dealing with a pandemic and there has been such an impact on small businesses, I fully expect that the Republicans will mount a pretty aggressive pushback in terms of this not being the right time to raise the minimum wage. But we can also expect the Democrats to also equally push very, very aggressively. So the question then becomes, in a larger legislative package, is there a trade to be made? Is there something on minimum wage that Democrats get minimum wage and Republicans get something else? Let's say it's liability reform, COVID-related liability piece reform that's been discussed by McConnell, or something else for small businesses. So I think that's ultimately where that lands. And then on the paid leave piece that you raised, absolutely agree. And if you recall, the first actual one of the first two bills related to COVID that were negotiated on a bipartisan basis, actually the centerpiece was paid leave. So first was the appropriations bill to address COVID, and second was a smaller package that Speaker Pelosi negotiated with the administration. And while paid leave, to your point, is becoming less relevant in terms of the COVID piece, I think from the Biden team's perspective, they actually do think that actually resurfaces with this whole discussion of variants, COVID variants. And so they do view it as a core part of stopping the spread of COVID in the future.
Yep. So I do think we're going to see some activity there. I'm going to turn it over to Gary to talk about two real quick issues. But before I do that, I'll just do one quick thing on occupational safety and health. It's at the end of our deck. But the quick note there is that, as expected, right out of the chute, you're going to get some sort of occupational safety and health standard related to COVID-19. I would expect that is essentially going to be some version of the CDC guidance that essentially becomes a standard at the OSHA side. And that's pushed out. I don't expect, again, given timing, that's going to be, you're going to see, you may see inspectors in, the weeks in after that comes out to make sure certain targeted industries are in compliance. But my guess is by the time most investigators on the enforcement side get around to most businesses, we may hopefully be beyond that COVID pandemic, and that will be less of a focus. But that's really the major thing on their regulatory plate right now, and they're going to have to move quickly on that. But Gary, talk real quick about a couple other initiatives that we may see in the administration.
Yeah, thanks, Nate. So one is with respect to arbitration. President Biden has indicated that it's a priority of his to try to eliminate the use of pre-dispute mandatory arbitration agreements and including class action waivers. This has the potential to be a real game changer in terms of class and collective action litigation, because many employers, especially since the 2018 decision by the US Supreme Court and Epic Systems, have implemented mandatory arbitration agreements with class action waivers, which to a large extent allows employers to avoid the risk of class action litigation. However, although this could be a real game changer with respect to class litigation, it's really unclear if there's enough Republican support for this in the Senate. And Archie, what are your quick thoughts on whether that has a chance of getting through anytime soon?
I think I will say on arbitration, there's a lot of intensity on both sides on this issue. So I think it'll be a huge food fight either way.
So maybe tough, unclear whether we'll see changes, major changes in that area. And then also with respect to non-compete agreements, President Biden has promised to try to eliminate the use of non-compete agreements to a large extent, unless necessary to protect trade secrets. And he also wants to seek an outright ban on no poaching agreements. Now, it seems that Biden has in mind a sort of a broad prohibition, maybe similar to what we see in California, which largely prohibits non-competes with only certain narrow exceptions. What may be more likely, if there is movement in this area, what may be more likely to get through is something more limited that, for example, may limit non-competes to high-level employees and highly paid employees, and possibly restricting how long they can last. So in recent years, a number of states have taken similar action. Washington State now limits non-competes to employees earning more than $100,000 per year. Colorado has certain prohibitions on non-competes, but exceptions for executive and management employees. Maryland recently enacted a ban on non-competes for employees earning $15 or less. And there's actually been several efforts in Congress in recent years, and some of those have had bipartisan support. I think, again, something similar to California, I think is going to be very tough to get Republican support for, but something more limited like banning non-competes with low-wage earners seems like something that might have a chance of getting through. Archie, do you agree with that?
Yeah, I think that's right. I think it's exactly the very skilled high-level executives versus kind of the folks who are at the bottom end. And I also would just add, I realized I didn't totally clearly answer your question on arbitration in terms of its prospects. And to be very clear, I think it's really tough in this legislative environment.
And Nate previously walked us through worker safety and OSHA issues. We're going to finish up with just a few quick points on what are a few things that employers can be doing now to get ready for some of these changes. One thing that I think is a good idea for employers using independent contractors is to review those practices. Because regardless of what new test may or may not get implemented, we should anticipate increased activity and enforcement around this area. Again, another priority for President Biden seems to be other aspects of employee classification, such as exempt employees. So reviewing those classifications is probably a good idea. We do expect to see pay data reporting coming, perhaps maybe not till 2022 or later, but we expect it to come back. So reviewing your systems for those capabilities to make sure your systems are going to be able to allow you to easily comply with those requirements may be a good idea. Assessing your non-competes and restrictive covenants may be a good idea. Even if it's unclear what might get through at the federal level, there's already a lot of different recent state laws in this area. So reviewing your compliance there now is probably a good idea. And also taking a look at your illness and injury protection programs. As Nate indicated, you probably anticipate some activity with respect to COVID, but even under current requirements, there's a lot that employers are required to be doing related to COVID and other issues. And so taking a look at that now would be a good idea. So with that, I want to open it up for questions. Actually, but before we get to the questions, just because I don't want to miss this at the end, is we have a raffle winner. And the raffle winner is, and I'm hoping I'm pronouncing it correctly, Wendy Ledesma from, well, I won't say where she's from, but she is the winner of our raffle. So congratulations, Wendy. And with that, I'm going to open it up to any questions that anyone has. So let me take a look here and chat room and see what we have. Try to get to as many of these as we can. Let's see. Well, let me start with just generally, and I'm going to put this out for Nate and Archie to try to answer, which is what do you think, which changes, which of these changes do you think are the most likely to happen, especially out of the significant changes that represent significant changes in the law? Nate and Archie, what do you think is the one or two things that you think are most likely to happen where we will see, whether it's legislation or something else, get through?
I'll talk on the regulatory side and then leave Archie to take care of Congress because she knows what she's talking about there and I don't, or not as well as she does. On the regulatory side, I think I certainly expect that you're going to see, obviously we've talked about undoing a lot of these Trump era policies. Obviously that's going to happen, but I think the real focus for the Biden administration is going to be in a couple of categories, and this will be across agencies. One will be independent contractor and joint employer. And so we know those are going to come off the books, and we're virtually certain that something else is going to go back on the books. And it will probably look a lot like what we saw during the Obama administration, whether it's going back to Browning-Ferris through regulation or through the board, whether it's going back to the AI interpretations at the DOL in the wage and hour context. Expect those to come back. I don't think it's likely, and I don't think they could really regulate an ABC test given the body of law around how this is analyzed. But I do think at the regulatory level, they will definitely address independent contractor and joint employer issues fairly quickly. At the union level, obviously you're going to see certainly they're going to go after specialty healthcare and Purple, and as I said, Browning-Ferris, and try to get those back to where they had them in the Obama administration. And then I think they will try to continue to pressure federal contractors on a lot of these issues, both union organizing, which is a very difficult thing to get through in an executive order because of the free speech issues involved. But I think they'll give it a try. And I think they'll try to push through, higher wages, paid leave, what have you, through federal contractors. It's just the path of least resistance for the administration to push some of these things through and show some results for what they've got. But other than that, I think really the focus will be and very much in the kind of core areas of wage and hour, NLRB, showing the unions are doing something and doing what we've been talking about, and pay equity will be, I think, the primary areas of focus. So legislative side, Archie.
Thanks, Nate. I would say, as we mentioned, the legislative environment is tough. I think historically, labor issues have been hot button issues on both sides of the aisle for Democrats and Republicans. I do think the Equality Act does have a chance. And I think the other piece is what we started our discussion with today, is that anything COVID related. So there are a number of pieces of that bucket, but what really stands out to me is the frontline worker protections, OSHA protections in that piece. Anything COVID related, I think will have a shot. And then the last observation I would leave you all with is that standalone legislation on the labor front will be much more difficult. So when we look at these provisions, they will be more likely in a bigger package, and that carries them over the finish line.
Great. And Nate, I got a question here about the FCCRA that I may be able to address. The question is, if the FCCRA is expanded to employers with over 500 employees, will local ordinances be taken into account and a preemption built in? Do you have any thoughts on that?
Yeah, it wasn't part of the first round of FFCRA paid leave. They really didn't address that, how that would necessarily kind of interplay. I do expect that if they expand FFCRA leave to larger employers, that is going to be actually a point of emphasis from larger employers as they work with Congress to try to make their views known, because it is, obviously that employees shouldn't be getting two separate buckets of leave on this. It's one thing to allow, I think, some extra leave at the local level beyond, but certainly there'll be some harmonization that's done to make sure that, I would expect to make sure that there's not kind of double recovery, so to speak, on the leave. I would be surprised if the Biden administration pushed complete preemption of local laws on paid leave, either COVID related or otherwise in this context, other than harmonization. I can see that being a ask from the Republican side. And at that point, it comes down to Archie's typical horse trading about who can get what for what. But I do certainly think there will be some effort to harmonize the various leave laws so that this new FFCRA leave is not added on top of basically the same leave that people may already be entitled to.
Great. And just following up on that, another question about paid leave. Question is whether how this American Rescue Plan of 14 weeks of paid family and sick leave would actually work. For example, do we know what types of businesses might be required, whether what type or size of businesses might be required to offer this type of leave?
Yeah, so the expansion, it is expanded and it would be going, at least as proposed. And, you know, if we saw legislation introduced, would be proposed to go to a larger group of, you know, to basically all employees. The tax credit that was available under the old FFCRA paid leave would be only available to those under 500. So there would be some features that carry forward. But there would be some additional factors, I think, that you know, additional coverage that would be out there. But the type of leave that would be permitted would be basically the same as under the prior act. And because it's COVID related, there will be, you know, that will have a limited shelf life. I do think, you know, there were some fairly controversial regulations that were issued around when you could take this FFCRA leave that are still out there that the Biden administration may try to liberalize a little bit. But I think the legislation itself would be focused more on continuation for those who've already been given it with the tax credit, and then expanding it beyond those folks for others. And while we're on it, I'll ask one question of Archie that I know is on everybody's mind, which is, tell us what Congress will look like in 2022. Will we still have a Republican Party? Will it be two parties? You know, look into your crystal ball and tell us how life looks in the second half of the Biden administration.
Well, thank you, Nate, for that question. I would say this, a few things. I think the ground shifted significantly in January. So generally, if you are looking at unified Democratic control, the conventional wisdom would be the midterms would be bad for Democrats. I think what we have seen in this past election, one is that Trump was actually quite helpful to the Republicans in terms of getting them over the finish line in terms of just winning in various districts and states across the country. So I think the first and foremost question is what do Republicans, you know, do outside of, you know, it's kind of, they're walking a tightrope in the sense that many want to move forward, but at the same time, their electoral prospects were very much grounded to his branding, not the Republican Party's branding, but Trump's branding. So we will see a realignment within the Republican Party, and that'll play out. And I think that provides opportunities for Democrats. And I think the other piece that we've also seen is, as you look at younger voters, their priorities more aligned with the Democratic Party, which I think all of these factors put Democrats in good stead for the midterms. So I think they will be able to hold their own, but it's still always historically a tough battle when you have a Democrat in the White House for a midterm election.
Thank you everyone for attending, and thank you to the ACC for having us.
Thank you very much. It was a wonderful program. And also, I will be sending the certificates and the slides in the next couple of days, and there's no code because we do track you.
The PowerPoint will be sent around at some point soon, and our names are all on there for you to reach out. Thank you.
Thanks, everyone.